Good afternoon, distinguished guests, faculty, students, and friends. My name is Christopher Batarse. I'm the Master of Ceremonies. Today, September 17th, Constitution Day, we celebrate the 238th anniversary of the United States Constitution. In doing so, the Society of Constitutional Policy, or SCP, is honored to welcome Professor Raymond Koo, the John Homer Capp Professor of Law at CWRU School of Law, and Professor Avidan Cover, Director of the Institute for Global Security, Law, and Policy at CWRU School of Law. They will discuss executive power and imperial presidency. Recent Supreme Court decisions have led to extensive discussion and debate regarding the limitations of presidential power and separation of powers. Observers note that the term imperial presidency dates back to President Richard Nixon's administration. Typically, it refers to a U.S. presidency that exceeds its traditional or constitutional limits and accumulates power at the expense of other branches, particularly Congress. Now, please allow me to introduce the panelists. Firstly, Ms. Sophie Dasko, Ms. Ella Simperman, and Ms. Lauren Hodge. Now, please also join me in welcoming the moderator, Ms. Catherine Fang.
Thank you, Mr. Batarse. Ladies and gentlemen, as Mr. Batarse mentioned, we are here to celebrate the United States Constitution, discuss executive power, and share reflections on a possible imperial presidency. A recent decision by the Supreme Court of the United States addresses federal power and presidential immunity to criminal prosecution, bringing these ideas to the forefront. Speaking today is Professor Raymond Koo, John Homer Capp Professor of Law at the Case Western Reserve University School of Law. A leading scholar, Professor Koo has written extensively on constitutional and administrative law, focusing on matters such as free speech and surveillance at New York University School of Law. In addition, he clerked for Judge Timothy Lewis at the Third Circuit Court of Appeals. Serving as discussant is Professor Avidan Cover, Professor of Law at the CWRU School of Law, where he focuses on national security, human rights, civil rights, international law, and ethics. He was a Gibbons Public Interest and Constitutional Law Fellow and has previously served as senior counsel in Human Rights First's Law and Security Program. Professor Cover was also a Fulbright Scholar in Nairobi, Kenya. Concerns about the president wielding authoritarian power have underpinned the debate for ratification. Many of the Federalist Papers, written by James Madison, Alexander Hamilton, and John Jay, under the name Publius to argue for the adoption of the Constitution, are devoted to the executive. For example, Federalist number 70, written by Hamilton, defends the strong single executive in the face of arguments that an energetic executive is inconsistent with the genius of Republican government. The essay argues that the unitary executive allowed for a vigorous and decisive government, as division in the executive would fundamentally weaken it and impede the government in emergencies. In addition, Federalist Papers number 68 and 69 addressed checks on the president, noting that misaction of the executive would be corrected and punished through impeachment or accountability during potential re-election. Since then, the debate on presidential power has shaped the present and future of the country. Today, Professor Koo and Professor Cover will examine the implications and unfolding ramifications of recent Supreme Court decisions. What is the current state of executive power? Professor Koo will discuss what the framers of the Constitution said about executive power and how the Supreme Court has tackled constitutional checks and balances that would prevent this president from exceeding his power. Professor Cover will discuss the historical basis of the imperial presidency and the expansion of executive power. Professor Koo, you'll have 45 minutes for an opening statement. Professor Cover, then you'll have 15 minutes to share comments. Professor Koo, the floor is yours.
Thank you very much. Thank you all for inviting me here, and thank all the students and faculty for helping to organize this event. Constitution Day is obviously a very important moment and an important part of our civil and civic reflection on the nature of our government and our responsibility and role in that government. The introductory remark was interesting. I hadn't thought about the connection of imperial presidency to Richard Nixon, and so I just want to drop one little thought before I begin, which is it's odd that Richard Nixon had to say that he was not a thief and not a crook, and yet our current president had to say, I am not a dictator. Right, and so we'll find out more about what you think about that as we proceed in this discussion. Right, so while the overall theme is the imperial presidency, I want to emphasize the idea of the unchecked and unbalanced presidency, and especially the role the Supreme Court has played in making that the current state of our affairs. Right, so. President Trump was recently quoted as saying, I have an Article 2. I should put sick in brackets there for all of you English writers, where I have the right to do whatever I want as president. Right? That was soon followed by this eye-opening, shocking tweet from the president as Robert Duvall, and responding to Apocalypse Now, and warning Chicago that they were about to find out why it's called the Department of War. Now, obviously, for many of us, this was quite shocking, and given that this was the president's own official account, not something that we might necessarily consider immediately a satire. Right? So what have we seen since President Trump took office? Right? First, we've most dramatically, as the Chicago threat suggests, we've seen American forces put into cities and the District of Columbia over the objection of state and local leaders. We've seen the extrajudicial arrest, detainment, extradition of non-citizens, all without due process. We have seen the president unilaterally impose, pause, modify, and individually tailor tariffs around the globe, even with longtime allies and trade partners. We have seen the president take steps to withhold billions of funds to institutions of education, both public institutions at the secondary and primary school level, as well as institutions of higher education, public and private. Right? Harvard, of course, being the most visible example with one of the largest financial risks in play. In addition to that, right, if they did not comply with the kind of idea of trying to reobtain those funds by complying with the president's demands, and I emphasize the president's demands here, right? Not dictated by law, not dictated by departmental policy. These are the wishes of the administration, that they would be subject to future punitive action, including losing tax-exempt status. Now, he's then added to that mix the idea that under these circumstances, we would also be firing federal workers. Right? You might all remember that as originally part of the DOGE effort at governmental efficiency. Right, so in addition to firing those workers, we would be dismantling various departments, including the Department of Education. He has also fired now democratically appointed leaders of independent agencies. He has required businesses, domestic businesses, to pay to the U.S. government for the privilege of exporting products abroad, NVIDIA being the example that I'm using here. Right? This is, as far as I can tell, the first time in American history where the President of the United States has, in his view, positively earned and acquired a stake in a privately held corporation as part of his public function. Right? And of course, most recently, the president has ordered the military to attack two unidentified vessels in international waters, alleging that these were drug vessels. Now, whether or not that factual allegation is true, we do not know, but we do know that this is not part of any official congressional authorization, and we are quite skeptical, according to some of the reports, about exactly how much they knew and when. So, all of this is facially unconstitutional, full stop. Right? This is the conclusion reached by every single district court that has considered these matters. It is the position that lawyers around the country, myself included, have advocated to our own institutions who've been under these threats, as well as to clients around the nation. Why? It fundamentally violates the separation of powers as the Supreme Court has recognized it, going all the way back to Marbury versus Madison. And if you want anything more recent, we can go back to a dispute between President Truman and Congress during the Korean War. It also attacks institutions based on their freedom of expression and freedom of association. It does so in ways that are both punitive and tying demands to essentially the sacrifice or alteration of one's exercise of one's First Amendment rights. Consistently unconstitutional. Prior to President Trump's inauguration, the Supreme Court had just stated that even threatening or kind of implying threats of investigation were violations of the First Amendment. So it violates due process in the sense that when we detain individuals, when we even arrest individuals, we must have the sufficient evidence and a process in place to ensure that, one, you have identified actually the correct individual, and two, that the concerns that you're raising are in fact legitimately criminal concerns, right, as opposed to the pure discretion of the investigating officer or the agent in charge. We have also very clearly dangerous equal protection issues, right, as the targets of the president's ire are all very selective. Right? They are institutions that either the president has identified as being in opposition to him. They have been law firms that have employed attorneys that in one way or another have worked in cases against them. Even members of the Republican Party who worked in the Department of Justice and did their jobs as members of the Department of Justice have been targeted by the president. Right? Let alone, you probably all know that his former Secretary of State has had the FBI mill through his files as a means of kind of retribution for writing a very critical book about his time with President Trump. Right? So these are all fundamental constitutional concerns. Now, you could just write this off as this is a lawless president and as such an aberration, and so maybe we should just hold our breaths and kind of wait for the midterms or the next presidential election. I'm going to argue here that it's much more serious and deeply concerning than that. In large part, it is not just the president's own discretion or interest that's motivating this. It is based upon a theory of the unitary executive that suggests that the president is vested with inherent executive powers. My apologies, I hate any kind of presentations where the slides are essentially read, but some of this will be inevitable here. And under these circumstances, right, the idea is the president is in all respects commander-in-chief, head officer, leader of the United States government, even in light of our separation of powers and the text of the Constitution. This especially means that in areas such as national security and foreign policy, the president's decision-making and discretion are essentially unbound and unchecked. In fact, my former colleague, Jonathan Adler, argued that in essentially a Wall Street Journal op-ed last week, arguing that regardless of what we think of the tariff policies, the foreign policy aspects of implementing tariffs give the president wide latitude in doing things like this. Right, and then, of course, lastly, what brought us here was Trump versus United States, and the argument here that as president, I am also absolutely immune from any actions I take while serving in the office. So that's the theory. Now, where does this come from? Right, obviously, in part from lawyers and academics, but what's the basis for their theory here? Right. The primary theory is, in their argument, an original understanding of the separation of powers of the Constitution. And their primary textual basis for this is Article 2, Section 1, the beginning clause of the creation of the executive branch. Now, so my premise or question for us today is this original understanding consistent with the original understanding? And so this whole process got me to reread the Federalist Papers. I'm an academic, so this is an enjoyable process. The context, however, might not be what I would have desired. So delving into what the framers actually said, well, the spoiler alert here is no, it's absolutely not consistent with either the text of the Constitution or the original understanding of either the Anti-Federalists or the Federalists at the time in the debates over the adoption of the U.S. Constitution. Now, are there other authorities out there? Sure, maybe. Would they normally be considered as authoritative as either the Anti-Federalists or the Federalists? The answer is usually no, right? And the importance of identifying who that authority is obviously one that would be central to this discussion. So let me start with what I always do, and my students both either love it or hate it, and it's with the text. From my perspective, nothing in constitutional law begins without the text. And so, as I've already suggested, the primary emphasis here from the proponents of the unitary executive is Article 2, Section 1. It is the initial vesting clause, and here it says that the executive power shall be vested in the President of the United States. As a former professor of mine used to say, well, read on, right? And so one might take one interpretation away if that is all the Constitution provided, right? And in fact, when one looks at the first three articles of the Constitution that create the three separate branches of power, they all begin with this language, with the exception of Congress, where there's a little bit of a modification in there. But the idea that these are the branches that will be treated as part of the traditional understanding of the separation of powers. Right. Now, the important part for me also comes following, right, which in addition to the general vestment is Article 2, Section 2, which then specifies the different aspects of the executive branch and presidential authority. Right, so this is where you see with a great deal the commander-in-chief of the armed forces. You see the idea of the president has the power to make treaties, to nominate and appoint members of the ambassadors, to judges of the Supreme Court, et cetera. And the kind of catch-all clause, in some respects too, is the authority and the responsibility to take care that the law be faithfully executed. Right. So in the past, proponents of the unitary theory have argued that it's this complete amalgamation of the text and the language here that essentially recognizes the full scope and the broad discretion of a president. Right. And, given Trump versus United States, beyond re-election and impeachment, are there any other mechanisms for political accountability? And if, under our purposes here again, Article 1, Section 3, Clause 7, when it talks about impeachment, it is then followed with this important language, that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So that's the text. And I welcome you to examine the text for yourself. I welcome you to make decisions about interpreting the text for yourself. My job is here to present it as objectively as I can and let you judge my conclusions. So that's what we have. So what was the original understanding as written and as we have as evidence from that time? Right. So I want to begin with the Anti-Federalists and Cato here. Right, and why this helps give us context. Right? So after the convention released the Constitution and submitted it to the states for ratification, it was not unanimously considered the appropriate document to govern the new states. They had just obviously thrown off the monarchy and had existed under a system of government under the Articles of Confederation that granted states much more political authority, much more aligned with the European Union when we think of it today. So greater sovereignty, smaller national government, less national authority. Right? So here the framers of the Constitution came around increasing national authority, increasing the reach of the federal government, and doing it in a way that was largely inconsistent and new in many respects. Right? So Federalists today, no connection to the Federalists of the 18th century, emphasize the importance of the division between the national government and state governments. The idea of federalism in that sense is considered an innovation in the U.S. Constitution. The more important part for us today is they didn't follow the traditional Montesquieu, for those of you who are political or history majors, a theory of separation of powers, right? Strict separation of authority between the executive branch, legislative branch, and judicial branches, right? England operated under a system of separation of powers. And so we'll see many of the comparisons that the Federalists make will be towards England. And what do I mean by that? Well, the framers did what some might call the bastardization of the separation of powers, right? That's why we have checks and balances, not a pure system of separation of powers. Right, that in their view, we wanted to create a system of government where the executive played a role in legislation, where the legislature played a role in involving the judiciary, and back and forth. And so there are various elements that were, in fact, melded between the traditional separation of powers and the authorities of these three separate branches. Right, so Cato here and the Anti-Federalists were primarily concerned with the idea of that there were no Bill of Rights, as many of you have heard, and that Congress and the representation under the Constitution was too narrow. Right? They believed that Congress should have been larger in its current structure that was proposed would simply be filled with elites and represent the interests of elites as opposed to the interests of the average person. And by the way, in terms of the Bill of Rights, they were not talking about what we consider the first 8 amendments to the U.S. Constitution. They were using language at the time which referred to essentially quotes from the Declaration of Independence that recognized the inalienable rights of all of us to life, liberty, and the pursuit of happiness. So my common law students find out how that plays out later in our debates over this. So what is Cato otherwise concerned with? Cato is the only one to specifically address the presidential office and the executive branch. Right. And first, as many commentators have written lately, well, there's a little problem with Article 2, Section 1, and the idea that executive authority is vested in the president. What do they mean by that, right? So his argument is this is vague and inexplicit, and as such could clearly be manipulated in a way that undermines the liberties that are supposed to be protected. Well, there are a whole lot of what he considers to be threats to the republic itself, right, under the scheme that they create. Right? And as you can see, many of them are playing out in the debates and concerns we're having today. right? That the president's appointees, the people that will come on board with the president, will essentially enable the president to exercise much greater authority than the text of the Constitution might in fact delegate, that the control over the Army, militia, and the Navy could be fundamentally disruptive, despite the idea that the Constitution limits the president's role to commander-in-chief. And I'm not sure how many of you caught the additional language, when actually called into service of the United States. Right, so some people like to ignore or forget about the following clause. And the idea of granting pardons, which we have now seen in multiple administrations to individuals who have engaged in treason. The anti-federalists were especially concerned that what this does is allow the president to be the lead conspirator in any attempt to overthrow the elected government or, say, prevent the transition of authority between one government and another through the use of the pardon, through the offer of pardons, etc. And lastly, and this will be important for part of the other discussion in terms of the unitary theory, is duration. The anti-federalists wanted a much shorter term of presidency. 1 year was one of the proposals, and term limits as an important aspect of this. Right? They did not want the president to be able to accumulate exercise that much power, accumulate more power over the term of the presidency, over what they saw, right? And Franklin Roosevelt proved it, over a virtually unlimited number of terms. Right? So they saw that as a threat. Right? So in his view, in Cato's view, what's the concern here? As written, the text of the Constitution allows the president, if the president wants to ruin the country. Right? And so that there weren't sufficient checks and balances even under the text of the federal Constitution. So as has been mentioned, the Federalist Papers have been generally considered the primary source of the Federalist response to this, the defense of the actual language of the Constitution, an articulation of the reasons and the purposes for which it was written. And so John Jay on the left, most of you probably don't recognize him. Alexander Hamilton, many of you probably do recognize, thanks to Lin-Manuel Miranda, and James Madison on the right there, the three primary authors of the Federalist Papers. I will not be referring to these Federalist Papers by Hamilton, for example, who is the primary writer of most of the ones I will be referring to, because they wrote under the pseudonym Publius, and so at the time of the consideration, their identities were not known. Right? And I think that there are strategic reasons, more than just historical reasons, to attribute any particular Federalist paper to an individual writer. Right? So, response, pretty simple, straightforward. We did not create a king. Right? We just overthrew a king. Right? They had all fought in the war. They had lost family and friends. They had sacrificed or risked their lives and their sacred honor, and they were not about to replace one king with another. Right? So the role here it was how to explain and respond to the anti-federalists that what the Constitution was doing was creating a strong executive, that one that's necessary in a system of separation of powers, where the Federalists were fundamentally concerned that in our system, the legislature was actually the greatest threat to individual freedom and safety, not the president, not the executive. Right? True both at the federal level and at the state level. And so this is one of my favorite things as a professor, the ability to go through and find someone else's summary, point by point, right? And this is language from the Federalist Papers itself, right? So why is the president not a king? He's not immune, right, from prosecution. The president is subject to and amenable to personal punishment. Disgrace, I leave that to each an individual subjective view about what disgrace means. King, absolutely immune. Right? Their king's role is completely sacred and therefore inviolable. In terms of legislative action, qualified. Right? So the president could veto legislation. And as I'll mention a little later, the framers fundamentally viewed the veto power not so much as a way to avoid bad law or policy, but as a means of the president to protect the president's own authority from intrusion by Congress. And so those of you who care about the creation of administrative agencies and the roles of the presidents, as we'll talk about, in controlling them, the veto is a primary example of what the president's role was as it was envisioned in the Constitution. Right? So if the president's going to give up authority to Congress, the president has the ability to deny Congress that request, let alone demand. The right to command the military. Right? And here, command is what they emphasize, as opposed to declaring war, raising and regulating the military, right? Which is much broader authority that kings could exercise. Concurrent authority with the legislature in treaties, right? Not sole authority. Right? That was the discretion of kings. Concurrent authority in appointment. Not unilateral. Unilateral authority, again, was the prerogative of kings. And the idea that the president has no authority in the last two to confer any privileges to individuals, where the king could do whatever the king wished. And more importantly, the president has no authority to regulate commerce or currency. Not under the Constitution. Whereas, again, the king could be the ultimate decider, depending on which president you want to quote here under those circumstances. So, you know, what is this? It's kind of an odd, listening to this, myself personally, rereading this made me think, like, well, that's a very, very kind of contrarian view of the presidency than most of us might have been exposed to, and certainly in the public debate today. So with a little bit of, just one little bit of edit there, this is another statement from the Federalist Papers. What is the actual job of a president? Executive details. All right, so what are we looking at? Actual foreign negotiations, what they describe as contract negotiations, not determination of foreign policy. Right? And even in that negotiations and treaties, Congress's consent, and 2/3 consent's required before those treaties are adopted and become law. Financing. Determine how to prepare a budget, propose a budget to organize and institute and run a government, prosecutor's office, administrative agency, and the military. Nothing more than that, right? Those are recommendations to Congress with the final authority on determining those issues. And again, dispersing funds as dictated by Congress. Not as the president decides that this is an important policy or this is a preferred policy. The president doesn't have that authority. Largely ministerial here. And of course, the one that is the least ministerial is the command of the Army and Navy. But under those circumstances, we'll discuss later, the president is considered the general-in-chief, not the idea that the president has full control over military forces. Once again, that power is left to the legislature. All right, so here, again, thank you, Publius. What does this mean, right? And they give us a nice explanation for, by the way, it's Hamilton, all right, why do we want what we're going to discuss here? We want unity, duration, and support, and competent powers. Right? And what does that mean here? We want well, let me hold off on that. Secondly, how are we going to ensure that this individual in this office that create does not run afoul of individual liberties and Republican principles? One, we are going to, in fact, rely on the people under these circumstances, and that, in part, is significantly going to be the representation of the people through Congress and by the specific powers and responsibilities that we delegate to the president. So this is, in their view, supposedly a very, very coherent and overarching understanding of how to create this new executive. Right? So the unitary executive people are not wrong in saying that the Federalists use the language of unitary executive, that it should be vigorous and there should be energy, and that energy is fundamentally important here. But what they were talking about under those circumstances was, oh, what happened? Why am I? There we go. Not one department, one government. It was one person. Right? What they were discussing and what the anti-federalists wanted, and the practice in some of the states at the time, was to have the presidency or the executive run by council. Right. So you can all imagine, just at a very personal level, the idea of governance by committee, let alone governance by faculty, how efficient or effective that might be, how nimble it might be in responding to changes in circumstances. Well, Hamilton's fundamental critique of the anti-federalists is that history has demonstrated that governance by committee it definitely leads to failure. It might be, as he suggests, what you want in the legislative process as policies are being determined. But once those policies are decided, hesitation or unwillingness to apply those policies was in their view problematic. And so this kind of idea of we want the executive branch to enforce the law as determined by Congress requires action. Now, how does governance by committee violate that? Well, the more people you add to the room, the more interests you add, the more opportunities for self-interest to invade the process, and the greater opportunity for obstruction to occur. Just as importantly, not more necessarily more importantly, is the ability to avoid accountability. Right. In a committee context, especially one that's confidential, which was a circumstance that existed, for example, in New York at the time, it would be quite easy. I supported your policy. I wanted to achieve this objective, but I was overridden by the members of the committee. Right? So finger pointing would be a way in which accountability could be denied and allow the frustration of government to occur. Right? So we're not talking here of the unitary executive in independent and inherent powers. We're talking about the number of officers that should head a specific branch of government. All right, so, along those lines, what about national security and foreign policy, right? These are the president's major portfolios, right, in which the president should have the greatest leeway and discretion. We're constantly told that. The Federalists point out that there's not a whole lot of actually delegated, specified powers to the president in this regard. Right? So national security, commander-in-chief. Right. And as I said earlier, believe it or not, the emphasis, the all caps, predating text, was in fact in the Federalist Papers itself, and just essentially said, if you think we're creating a king with all these powers over the military, let me give you the qualifying clause, which is when called into the actual service of the United States, which, as most of you will know, is provided specifically to Congress under Article 1. Now, the framers did recognize that there might be some circumstances which calling the legislature together might be problematic, and the reason why they use the specific language Congress has the authority to declare war was, well, what happens when there's an invasion? Does that mean that the president doesn't have the authority to call up the armed forces in defense of the nation? To make war was the original language, so they drafted it in a way that Congress would still retain the authority over ultimate military authorization, except in the kind of cases of emergency. Now, foreign policy, right? And so in that sense, they're very clear, and the Supreme Court has recognized this more recently, that commander-in-chief power means direction of the operation of war, right? All right, boy, I'm going to have to move a little more quickly here. On foreign policy, negotiating treaties. That's it, negotiating treaties, right, which they share concurrently authority with Congress. nominating ambassadors, not appointing them. Right? The appointment part requires, again, concurrence with Congress. And lastly, the Federalist Papers make very much light of this, and many of you may agree, entertaining and receiving ambassadors, right? Which may either be a privilege or a punishment. So why do that? Why limit the president's discretion in these two important areas? That was not accidental. Ironically, they argued that, well, you know, a king might actually have more concern in these areas than an elected president. A king might be concerned about the legacy that they would leave behind, which is fundamentally tied to them and their family. An elected individual, however, they were concerned, would have no such concerns. And what would that mean? Well, the language is up there for you, that giving a president that much authority would allow them to essentially use that position of authority to put their own interests above the nation. That's all right. There's a lot of this that, you know, many of us might have said, yeah, no duh, right? But what I'm doing here hopefully is giving you the clear legal authority to reject those particular arguments. And let me go through this a little briefly here. Right, so on the whole faithful execution of laws, right, this is where you're fired fundamentally comes in these days, or we need to deal with the threats of immigration or now potentially drug couriers. Here again, the role of the president is to nominate individuals that will serve in their administration with the advice and consent of Senate, and for an important element here, including the removal, Senate's concurrence in the removal of presidential appointments. This is very controversial today. It's an argument being fundamentally rejected by the majority of the Supreme Court. But it is very clearly in the Federalist Papers that Congress retains the authority to consent to removal, right? And why? It's not about the president having the president's team. It's about the effective and faithful administration of law, right? And they recognize too much turnover, too much discretion in the ability of each new elected official to come in and replace the entire, all the members of government would be incredibly chaotic and ultimately serve to undermine the effectiveness of public law and government. Now, legal accountability, as I already said, impeachment's one method. The Supreme Court will essentially say that might be the exclusive method. But here again, the Federalist Papers are very clear. Once the president leaves office, a major limiting factor on the president's discretion and abuse of office would be that they return to the status of every other individual in the republic and subject to criminal and civil liability. So how do we get to a world in which President Trump can, with quite straight face, make the arguments that he's made, taken the policy steps that he's taken, and normally I would not do this, but I'm going to all lay this on the feet of the Roberts Court and arguably on Chief Justice Roberts himself. So why? Well, their view of the Constitution, following much of the unitary executive theory, says, well, we follow the theories of separation of powers as proposed by thinkers like Montesquieu, not Publius. Right? We interpret the Constitution in that sense, with the second clause there, that any limits upon the president must be strictly construed. Right. Why? Because their understanding is that, or interpretation of the Constitution, we have a separation of powers in which we divide power and responsibility everywhere except for the presidency. Right. Now, I'll ask you to whether or not that can be reconciled with the text, let alone what the framers then said about it afterwards. And then that what results in this is the fundamental idea that the president is directly accountable to the people. Now, of course, again, historically, wrong, right? No direct presidential elections. Even today, we still have the Electoral College as some filter between public elections and not. So famously, when he was going through his nomination process, Justice Roberts said, hey, my job is to call balls and strikes and not to pitch or bat. So what I'm going to suggest to you today is, yeah, he's probably being accurate with what he described there, except he's also allowing Trump to score without having ever come to the plate. And yeah, he's calling balls and strikes, but he's also letting the president reach home, right? Why? So I'm going to go through a series of events that have us here today. Right? Of course, January 6th, for many of us, a very, very disappointing day, to say the least. I had, in 30 years of teaching and dealing with constitutional law, or through various presidential administrations, been able to say that, at least in this new election, we are following an American tradition of peaceful transition of power. Well, January 6th made it impossible to say that. All right, so the president encourages individuals, helps, in fact, organize individuals to stop the steal. When the violence is occurring, he takes hours in order to address the public and ask for the violence to stop. And even as he does so, he says, we love you. You are very special. Now please go home. Congress, of course, creates its report, which forms the foundation for Trump's second impeachment. So why is this important? Right. Legally, and this is again where Chief Justice Roberts plays a role, the argument was you cannot impeach a president who is no longer the sitting president. As he had lost the election under these circumstances, Rand Paul, Mitch McConnell argued, and a number of individuals in the Republican caucus agreed. There was no constitutional or legal authority to impeach the president the second time. Obviously, if he had been impeached the second time, he would not have been allowed to run for the presidency as he did. Chief Justice Roberts, by example, if not by in word, backed up this theory and chose not to preside over the impeachment trial on the basis that he's not a sitting president. As a result, the constitutional obligation of the Chief Justice didn't apply. 2, not Trump versus United States, but now Section 3 of the 14th Amendment. Many of you may remember this specific controversy, right? That Colorado and Maine and other states were arguing that. Should I be able to go on? I mean, I know I'm a little over. Okay, thank you. That the president had, in fact, now violated Section 3 of the 14th Amendment, which precludes individuals who've held office and sworn an oath to uphold and defend the Constitution from having future offices and holding future offices. Colorado made this decision in the same way it would make every other decision regarding ballot access and the qualifications of the candidate, age, natural-born citizen, years of residency, etc. Decisions that have been delegated to the states by the Constitution and recognized by the Supreme Court as within the state's authority. Right? In fact, the justices themselves, several of them had been involved in cases where they just fundamentally quite easily upheld the decisions of the states under these circumstances, even though the parties argued that, well, this is a factual determination that should be left to the elector, right? Not enforced, certainly not enforced by the states. Now, the problem, of course, is they said that, well, this seems like it'll be a giant mess. Therefore, Colorado and Maine don't have the authority to do this, yet they left us with no merits decision on this. No, there was no comment about the process wasn't sufficient, or the evidence level wasn't sufficient, or that their reliance on a definition of insurrection or rebellion wasn't adequate. So it leaves us with the prospect of President Trump, as he suggests, running for a third term, right? And because you can make an argument, hey, 2 terms, 2 consecutive terms, right? And who will make that determination? The states that would be the ones that would be required to put the candidate on the ballot, or somebody else, right? The Supreme Court gave us no idea or any guidance under those circumstances. How about legal accountability? right, for the president's actions, right? So prosecution by the United States and Georgia, right, which led to the case that we're talking about here today, and Trump versus United States, where the court concluded that the president is absolutely immune for decisions made under his core constitutional powers and responsibilities. What that meant and what those core functions are, they didn't define for us. Whether or not, they did, however, make clear that when the president is being charged for activities that are outside those core functions, you cannot consider evidence that intrude into whatever those core functions might be, right? So obviously there's a great deal of wiggle room left here, and that suggests that maybe stop the steal, maybe find me the votes, maybe hang Mike Pence may or may not fall within the types of actions that are within the core part of a president's responsibility. Though the court does suggest that the calling Georgia may very well be part of the president's core responsibilities in the care and concern over federal elections, and we don't ask why he called Georgia and why he specifically asked what he asked of the state. So in many respects, that gets us to where we are today, right? President was on the ballot. President was not held responsible and not subject to prosecution that could complete before the election process. And now he's making these decisions. And you have all heard shadow docket. Perhaps Professor Cover is going to talk about it a little more. The shadow docket is the emergency docket, in which the court determines whether or not to lift stays or grant stays based on what's occurring at the lower court level. So here, the primary concern is not the issues that are being addressed, but how the court is dealing with this. Once again, in this process, the Supreme Court does not consider the merits of the case. They do not address the merits, though the merits are consideration at the lower courts. Right? Are you likely to succeed? If you're likely to succeed, well, then we have to consider whether or not allowing you to kind of preserve your status quo and protect yourself is balanced as part of the equities in the set of circumstances. So here, all the lower courts, again, that have issued these injunctions, these stays, have said that this is a violation of law and the parties are most likely to succeed on the merits of those claims given the Supreme Court's current law and current federal law. The Supreme Court has been regularly overturning these conclusions because they have essentially defined the balance of equities differently. They have said that in many respects, changes to the president's wishes are the harm under these circumstances, not upholding the rule of law, not the protection of individual expectation of job security, funding, preventing governments from coercing them to engage in activities that they would choose otherwise to avoid. Right, so under these circumstances, the Robert courts has described it, what I would describe as adopted a strategy of avoiding the merits by delaying and using a procedural process to allow the president essentially unfettered discretion. I'm just about ready to finish up.
Okay.
My apologies. So I want to emphasize here that one of the concerns that comes out of all of this, and I think Professor Cover will talk about this, is that it's been very clear since the Steele seizure cases and that this is not the most efficient system, right? If you want the trains to run on time, having Congress pass laws and having a president that enforce those laws is not the most efficient way to do it. Right. However, that's not the purpose of the Constitution. The Constitution is there to prevent abuse of power so that government serves the interests of the public and not any individuals or any groups specifically within that inconsistent with the interests of all of us. And here, most importantly for me, is Justice Jackson suggested that there may be different approaches here. You may not like that. You may prefer a different approach. Presidents always do. But courts should be the last institution to abandon these principles, to ignore the text, and choose to adopt their own personal preferences under these circumstances. I've been thinking a lot, very hard about how to end this. So I'll try to be brief since I've now run out of time. There's no way to sugarcoat this. This is a constitutional crisis. I am not alone in saying it. Most constitutional law professors have admitted it, quite frankly. Right now, we have an administration that is fundamentally lawless and unchecked. Full stop. There's nothing else I can say about that. Whether or not you like the man, whether or not you agree with his policies, what the president has been doing is fundamentally inconsistent with the rule of law since John Marshall decided that judicial review was a fundamentally important part of the Constitution. So I can't sugarcoat this for you. There are no checks and balances on the President of the United States anymore. The system is fundamentally broken, and it's been broken by the people who are responsible for guarding and defending it. Now, I do want to say we've been here before. Right? The country has gone through arguably more traumatic and dangerous circumstances than we're facing today, and we've survived. We've arguably, in many cases, progressed, but we also know that there have been a bunch of things that will happen. It's only going to get worse. Before any improvements can happen, it will only get worse before it gets better. 2, no Superman or no superhero is going to come to save us. If we are going to improve our situation and preserve and protect our republic, right, as Ben Franklin said, if we can keep it, we have to do this ourselves. Right? And this process is going to be long. It's going to be painful. It's going to require collective action on the scale we have never seen before in history, or probably less than the collective action that we might be required to engage in to fight and combat climate change, end world hunger, any number of those even larger global issues. But in the United States itself, this is something we will not have seen before. We are talking about essentially mass mobilization over time to respond to a situation in which the political process it cannot be relied upon to save us. So let me end the only way I could figure out how to end here. So 12 score and 9 years ago, since the Constitution, more importantly, since the Declaration of Independence was signed, Abraham Lincoln said, "It's for us, the living, rather to be dedicated here to the unfinished work which they who fought here have thus so nobly advanced. It is rather for us to be here dedicated to the great task remaining before us, that from these honored dead we take increased devotion to that cause for which they gave the last full measure of devotion. That we are highly resolved that these dead shall not have died in vain, that this nation shall have a new birth of freedom, and that the government of the people, by the people, for the people, shall not perish from the earth." So these are not just words. Many of you may have known that an elected member of the Senate has said very specifically that these are not our values, that this is not our country, that Lincoln was wrong. And so the terms of this debate are clear. And the only way those of you who want to uphold and defend these values, like me, is to fight for them. So, thank you. My apologies for taking more time than allowed.
Professor Cover, you now have the floor.
All right, thank you. Thank you very much, Catherine. Thank you, Professor Tartikoff. Thank you for the panelists and everyone for putting this together. And thank you in particular, Ray. In many respects, there's not a lot of daylight, I want to disappoint you, between me and Professor Koo. But actually, I'm going to talk about a discrete area of executive power, and particularly in the national security space. And I guess I would say, perhaps as a descriptive matter, there may indeed be some daylight between us in terms of, at least I certainly would not assign all blame to the court for the situation that we're in. The trends in presidential war-making power that Arthur Schlesinger first documented in his book, The Imperial Presidency, back in 1973, led him to decry the uncritical cult of the activist presidency. And today, I think it's safe to say, those trends have only deepened and increased. Schlesinger was concerned that this aggrandizement of executive power at the expense of congressional power, Congress's acquiescence, and the court's limited engagement, was going to undermine the overall constitutional separation of powers and have impact in the domestic sphere. Writing during the Vietnam War, Schlesinger stated that President Nixon was not an aberration, but a culmination of these trends. What, we might ask, does that say about our current state of affairs and the sitting president as regards executive power and the imperial presidency? We don't have to look at only how presidents may use force in a singular way, but also explore how the president occupies increased powers in a blurred and metastasizing space of not just military authority, but it also includes international and foreign affairs, immigration, homeland security, drug interdiction, intelligence and counterterrorism, and even law enforcement. The imperial presidency rests in all of these areas. And here, as with initial uses of force, the presidency is aided not only by congressional acquiescence, but at times, and to invoke the Youngstown tripartite system, by congressional authorization. And indeed, often those authorizations are largely unlimited in terms of scope, duration, geography. And the judiciary, to the extent it chooses to engage, often it will disclaim jurisdiction, but when it does, precisely as Professor Koo described, is going to err in balancing those equities on the side of the executive. Oh, sorry, I'm doing the wrong one here. So I'll also go to our framers in the Federalist number 51, which reminds us that separate and distinct exercise of the different powers of government, it's not just some structural government matter, right? At the heart of it is the preservation of liberty. And indeed, this system of government, right, also has in mind the most vulnerable, that injustices will be waged by the majority. And so that is core to our divided government. And such accumulated powers in the executive branch can allow for the president to operate, in the words of Ernst Fraenkel, who Aziz Huq at University of Chicago has applied, to operate a dual state, where most of us enjoy the perks of a normative state, but there's also what Fraenkel and Huq call a prerogative state, where the president can choose to determine where the protections of law apply and where they don't apply, particularly those in outgroups. So what are the rules, so to speak of, in these powers in this area of national security? I'm not going to go over them at length, right? But we know sort of the core portion here. We have Congress, the power to declare war, and a number of others that might indeed relate to that. There's also, of course, taxing and spending and the like. And then we have presidential powers, right? And certainly we can point to, as Professor Koo noted, the commander-in-chief authority, this vesting authority. So on one hand, those seem pretty explicit. And I think it's safe to say, from the time of the framers through the 19th century, the president was not perceived as having the authority to lead us into war. Indeed, as some scholars noted, it actually was particularly the slow nature of Congress, right? It's a lugubrious, complicated fashion to pass laws, which was why they vested that authority in Congress. They didn't want the nation to rush into war. So what am I talking about, right? Is there really an issue here, right? Is it something beyond just the current state? Am I just a political hack? So according to the Congressional Research Service, in the history of this country, there have been 11 declared wars, numerous congressional authorizations of war, and thanks maybe to the War Powers Resolution, we know that at least since 1973, the president has authorized use of force abroad in some sort of military engagement 128 times. These are unclassified documents. Safe to say the number is likely a lot higher. And to be clear, there's no partisan element here. Presidents of both sides, Republican and Democrat, have invoked this authority. And Congresses of both sides have stood idly by and let that occur. But to today for a moment. Consider that in just the past 2 weeks, the United States has taken military action twice, including apparently killing purported drug traffickers aboard ships in the Caribbean Sea. Now, there was no congressional authorization for such force. The president justified his action. This is the report that he sends to Congress. States, in furtherance of United States national, he justified his actions in furtherance of United States national security and foreign policy interests and pursuant to my constitutional authority as Commander-in-Chief and Chief Executive to conduct U.S. foreign relations. The president issued the very same rationale for his unilateral military strikes in Iran back in June, really almost verbatim. So what are we to make of this state of affairs? This would seem an apparent non-compliance with the Constitution's rules. Well, an apologist, maybe it's me, or at least on one account, might venture that the problem of non-compliance is overstated, because the rules are perhaps less clear than both Professor Koo and I have presented them. Or maybe they've changed. Right? Perhaps hedging against such clarity of the relative roles of branches, we know that the framers understood that Article 2 permitted the president to use his powers in self-defense without congressional authorization in very limited circumstances. And we might argue functionally, at times of military crisis or events requiring use of force, we don't want to constrain the actors too much. There has to be flexibility, and we can look to righteous actions, right? Say, such as World War II, or President Lincoln's actions during time of crisis, even if they temporarily limited civil liberties. We're glad they invoked that power. But the problem is, we're at sea, we're in the wake of those precedents, right? Where the gloss of those quote-unquote righteous actions bestow more power as a matter of practice and precedent. And we might argue these checks and balances aren't as clear as we argue. And that rather than a bug, this is a feature of the Constitution. Right? As Andrew Koppelman has observed about constitutional law, what constrains constitutional law isn't really a set of rules, but a set of rhetorical norms. All right? They're unstable and shifting over time, and we need to determine which moves are legitimate. Another argument might be that, hey, times have changed. Right? Just as on the domestic front we have an administrative state, and we need so, the world's a complicated place, the United States is the global superpower, right? A status it gained after World War II, maybe earlier, and it's a dangerous world. This is not your framers' incipient nation, precariously situated, clinging to isolationism to survive. It would make little sense, advocates of political power or presidential power might argue, to hamstring the nation, right, with a slow and deliberate process that Congress plods along in. We need a fast-moving, secret-moving, forceful president. Sounds like The Godfather describing wishes for a child. This notion has found some judicial footing. On the one hand, we have, right, the Youngstown tripartite sort of moderate system where we envision that divided government. But there is also a counter view that predated Youngstown that Justice Sutherland offered, which conceives of this notion of the sole organ. So this is very much akin to the unitary executive, right? The president embodies our sovereign power and it exercises all external relations. And indeed, this part never gets as much of a quote, it doesn't even require a basis for it to exercise, or an act of Congress to exercise its actions, right? This is a very muscular view of presidential power, and it is one that you can imagine lawyers in the executive branch very much like to cite and do in their arguments. And while there's certainly plenty of criticism, I imagine our colleague John Enton would take a lot of issue with some of the work here, and some have argued a bastardization of John Marshall's views. It continues to hold weight. It continues to have persuasive purchase, if you will, in the executive branch. We might also argue, as some have, Deborah Pearlstein among them, that maybe the empirics don't really make any sense here, right? When we're talking about how can we really prove there's been noncompliance, and in fact, what she argues and some others have is that we're thinking of just sort of the bad man law mentality, that there are secondary norms that operate in the executive branch, and actually the president is exercising restraint all the time, right? We don't fully appreciate how often they are, and they're affected. They are affected by Congress. They are affected by the courts. They are affected by civil society. Sort of a low standard, maybe by which to measure, and maybe an overly optimistic one. And here's an important part to just appreciate. There is within the executive branch something called the Office of Legal Counsel. And because of all of the arguments, the functional arguments that the president needs to act with dispatch and often secretly, there is an Office of Legal Counsel that provides, particularly when there are branches in dispute, but will provide authoritative legal guidance for the executive. And these, often they publish their opinions, but often they do not. They never see the light of day. And these issues that the president takes are usually determined to be political questions. They're not even necessarily even litigated. And so what has happened over time is actually we have executive law. We have executive branch law that really constrains executive force. And this is the standard that they have put together in the executive branch. It's really like customary international law. It's sort of recognizing what have been the practices, why have we acted, maybe out of a sense of legal obligation. And so the questions they ask is this a matter taken out of national interest to justify the use of force? And then second, is it going to be limited in scope and duration such that it will not rise to the level of war in a constitutional sense? Well, I don't have enough time, but I think you could probably see that what on earth do those standards mean, right? They are incredibly broad. And when you have lawyers who have a singular client, a very powerful client, who is seeking to effect policy probably first before being constrained by the law, these are expansive and malleable terms. Ones that, again, President Bush exploited, President Obama exploited, President Biden exploited, President Trump exploited. Now, don't mistake both sides as too acute here. But this is a critical thing to, I think, appreciate. And there are real perils here. Some of you may recall after the 9/11 attacks, the Office of Legal Counsel created a memo predicated on presidential power, a very muscular notion, to say the least, of the commander-in-chief power that could override even a statutory prohibition on torture. Now, when this memo was leaked, not released, it was decried, understandably, by legal law professors and human rights lawyers and the like, rightly so. One of the things missing from the analysis, interestingly, was there was not a single mention of the Youngstown case. Like, that's legal malpractice, as many accused it, right? But that was executive law until, I should note, it was ultimately overturned. It was rescinded, though I won't praise the subsequent memos too much either. So I want to note here, and maybe this is appropriate, I think, to a lot of the things we hear. There's a wonderful concept. It's going to sound not particularly legalistic, that comes from Professor Jack Balkin. And it is a notion of the idea that in this space of contested constitutional law, there are off-the-wall ideas, right? And they're kind of exactly what you might think they might mean. But over time, and often to the chagrin, I think particularly of, say, a largely progressive law school, many of those off-the-wall ideas are no longer such, right? They are on the wall, as it were. And there's no more fertile a place to generate off-the-wall ideas than in the executive branch, in the secrecy and hothouse of an Office of Legal Counsel, where this power can be aggrandized and grown. I'm even out of my time to explain to you why it's so bad about what Congress has done here. And I'll just, the only thing I'm going to, one slide, is this, because this seems very appropriate. We are this week commemorating, we're not memorializing, 24 years this week. Congress passed, I think there was one opponent in all of Congress, for the authorization for use of military force. This is, Barbara Lee was the one opponent, that's right. This is what still governs the so-called war on terror. for the United States. This is what governs detentions at Guantanamo Bay and elsewhere. This is the basis for warrantless surveillance. This is the basis for a war against the Islamic State. Right? It continues to be the authorization that presidents of both parties, one party perhaps mouthing notions of winding it down, still applies. And I can point to things like, say, the International Economic Emergency Powers Act, IEPA, which is the basis for the tariffs by President Trump, or the Alien Enemies Act, which is the basis for detaining and seeking to deport Venezuelans to El Salvador. Right? These are laws on the books, on the shelf. They are, Justice Jackson, to invoke him again, the proverbial loaded weapon, but it's Congress that has allowed these things and given the president authority. So dangerous claims of inherent executive authority, but plenty of congressional authority. And I won't bemoan also, of course, how the courts have, by and large, been a willing partner to let these go ahead.
Thank you to... Thank you to both Professor Cover and Professor Koo. Just as a reminder for first-year students who want to sign in for the Explore program, the QR code is on that door. We will now proceed with questions from the panelists. Professor Koo and Professor Cover, you have 5 minutes, or you, whoever the question is addressed to, will have 5 minutes to address the question, then 2 minutes to respond to the other speaker's points, and finally, 1 minute to defend your original argument. I invite Ms. Dasko to ask her first question.
Professor Koo, Presidents Franklin Roosevelt, Richard Nixon, and George W. Bush were described as having imperial tendencies. What makes executive power imperial?
Well, those presidents are very interesting, right? In the sense that, yes, traditionally Roosevelt has been very much criticized for some time for the creation of the administrative state and his response in the New Deal in order to kind of respond to our both economic and political crises at the time, as well as World War II. For me, the question is with those individuals, or Nixon in its sense of abuse of authority, Bush, the kind of potentially dubious evidence used to justify the Iraq War, we have to ask what part how are they being imperial? Where are people being critical, or what are they critical of? Changing or instituting new government practices, right? Passing new laws, creating new institutions in response to new circumstances, to the extent that that is authorized or within the terms of the Constitution or a president's authority per Congress, right? Again, FDR, all the New Deal was passed through legislation, right? Through his wishes and then passed by Congress, signed into law. That might be considered imperial, right? If your authority is now being stepped upon by that. I don't see that as being imperial. I think the idea of dictating your policy and your personal preferences is what makes someone imperial, as opposed to the amount of power someone might in fact wield. So essentially to mislead the American public into one of the most costly wars in the end of the 20th century, going into the 21st century, would be an exercise of imperial power. Was it Nixon you used as the other example? Kind of using one's political office for, as Nixon rightly suggested, he was not a crook. His actual defense is, I never financially, personally profited from my office, and that is arguably true, right? But he did try to use the powers of his office to advance his political career and his political power. Right? At those points, those individuals are not public servants, right? Those individuals are serving their own personal interests.
Yeah, I would say, I think a lot of it fits within our conception of separation of powers. And I mean, that's at the heart of Schlesinger's critique, is, actually going back to the Youngstown case for a moment, and President Truman, I know it was not invoked there. Justice Black, in his opinion, said, the idea, the duty to faithfully execute the laws, which was President Truman's, refutes the idea that he's a lawmaker. Right? The suggestion was like, he is now exercising lawmaking authority. And when you exercise all of those powers, right, what distinguishes you then from a king, from a monarch? I think that's the critical piece. Certainly we can point to, look, there were actions, again, I think FDR, we look back to, the cause might have been righteous in terms of World War II, but there were clear violations of the law that understandably can lead to that imperial critique. And actually, just to harp on my notion of norms, right, generating constitutional law, we always know very famously George Washington, right, in the Hamilton show, right, said it's time to say goodbye, right? I'm only here 2 terms. And that becomes the precedent, not a constitutionally required precedent, but a norm that presidents exercise until FDR. And he exceeded that. And then actually Congress acts. We actually get a constitutional amendment, right? He went too far. That's the way the system is supposed to operate, right? When Congress, is asleep at the wheel, or actually just gives the car over to the president, it makes way for an imperial presidency.
Obviously, Professor Cover and I have known each other for a long time, and there's not much daylight between us in general. So I do want to emphasize, even with this point, the danger of assuming that constitutional law is and can be expanded to constitutional norms and the regularity or the familiarity of arguments made about those norms. I'm a lawyer. My view is it has to begin with some express source of legal authority that's either been established over hundreds of years through common law, then adopted into statutory law by our elected representatives, or to the extent that it is a founding document, that it's in the text of the document. Now, you can say, well, the text shouldn't matter, and in fact, some of the framers would be very fundamentally surprised that we are still adhering to it the way we are, though I would also say our Constitution is not this fundamental Constitution of 1789. The Reconstruction Amendments have fundamentally changed that. But that gloss is dangerous, right? Because the gloss is unsupported. And once you untether yourself from the text, what leaves either the president or the Supreme Court within any kind of boundaries or guidance of the law?
Thank you. Sorry, my apologies. I had the timing wrong. It's 3 minutes to address the question, 2 minutes to respond, and then 1 minute to defend your original argument. My apologies. I would invite Ms. Zimmerman to ask her question.
Professor Cover, under the unitary executive theory, the president has all of the power over the executive branch. What are your thoughts on the merits of this theory?
The merits? Well, from one perspective, I think that it is commonly held is, the president is elected, right? He is represented. He's the only office, right? We hear frequently, right, that is elected by everyone, that is representative of everyone, and therefore should be afforded the latitude to effect his policies, right? That is what the people have selected. And to constrain the executive in certain ways by various independent agencies is to undermine those policy preferences that the people have chosen, right? I mean, that's kind of it, I think, in a nutshell. And look, there's some power and persuasiveness to that, but I think, well, I don't want to steal Professor Ku's point, but some of what he alluded to, right, is the notion that going back to the origins time of our Constitution, right, to the framing, there was an understanding and appreciation that there was a need for independent expertise, and that Congress could indeed appoint those people. I think there's also a functional argument, it's sort of the mirror of this national security element, which is that we live in this complex administrative state, and we need smart, thoughtful people to help operate this very complicated country. And the idea of allowing the president to only select his people, right, is going to undermine the benefits of our overall society.
I mean, I was surprised about the stability and how serious the stability argument was at the founding era. Right? I tend to look back and think about this as a fundamental development of the administrative state and the importance and recognition of expertise in policymaking. I no longer could just say, well, I just think it's a good idea to have a traffic sign here when we're trying to deal with a national level economy, scientific issues that simply don't lend themselves to personal opinion, and therefore the need for the stability and expertise that come with that, right? I don't want presidents making decision on what they ate for breakfast in terms of what Iran is doing with its nuclear program. I would much rather rely on people whose job it is and training it is to look into those questions. But the idea that the framers, even at that time, with their small government and the small nature of our country, were still concerned that there is a government of laws, and that the president's job is not, while have some flexibility to make that happen as effectively and as best as humanly possible, not to change that. And yes, there is going to be wiggle room, but the danger is to say that wiggle room should become the full scope of discretion, and then that the interests of any given moment, the interpretation of any given president as to what his mandate or her mandate is, becomes fundamentally problematic.
Please pardon me for interrupting, but are the speakers and panelists willing to go to, say, 5:45? Because we really got a time problem here.
Yeah.
Yes. I don't want to have to wrap up in 2 minutes, so.
Sure.
Just, okay. So that leaves Lauren.
Yes, yes.
Professor Koo, how do you define and respond to a constitutional crisis?
All right. How do I respond to a constitutional crisis? So there are always going to be a great deal of numbers of political crises, social crises, economic, et cetera. The framers didn't, as Madison so famously wrote, didn't believe we were angels. Right? And none of them believed that we were rational, thoughtful individuals who would act beyond their own individual self-interest. They were fundamentally worried that that was going to happen all the time. Right? Anti-federalists were even more pessimistic about human nature and governance. Right? So they created a system. Right, a system that was supposed to control those negative forces and, as best as humanly possible, channel that into a system that would promote and protect the public interest. A constitutional crisis occurs when those checks and balances completely fail. Right? And not just fail at one branch, which may decide to usurp power that it shouldn't, and not in even circumstances in which two branches are in essentially collaboration here. In many cases, the concerns about legislative and presidential overreach are often circumstances when that occurs. Right? So Congress and the president are in unison on a particular course of action, and then the only question is whether the Supreme Court will support that, regardless of what the text or the precedent says. And in fact, when people talk about the dangers of the judicial branch, it wasn't necessarily the judicial branch as an independent branch, but as one in collusion with one of the other branches. And what we're seeing right now is the founders' assumption that there would be this desire to independently always preserve or protect my own turf as Speaker of the House, Senate Majority Leader, Leader of the Minority Party, or Chief Justice of the Supreme Court is not accurate when you have that kind of collusion and mutual complete understanding. That's when a constitutional crisis occurs. Right? And now I would add, too, when the internal checks on this abuse of political authority have been essentially removed. Right? Not just presidential protection. I did not add in my talk what has happened to voting in this country. Right? And in the same process that Roberts used in all those executive authority cases, he has applied to voting. Right? So, yeah, there are rules that burden voting, right? To define those handful of uneligible voters, we are going to make it more difficult for thousands of people to cast ballots. Gerrymandering, arguably, they say, unconstitutional. They will accept the idea that explicit partisan gerrymandering is unconstitutional, but there is no solution that the court can reach So we have to rely on a broken political system that the court has allowed one side to make fundamentally more difficult for people to exercise, and we've seen that throughout our history, to fix itself. And that is, in my view, the ultimate constitutional crisis. There's no solution other than mass mobilization or essentially devolution into violence.
I share a lot of these concerns. Voting is everything right now, because I would, and that's I think we would both end with, right. The will of the people is what's vital here. The will of the people selected Donald Trump as president. There was no. They knew what they were getting. Right? He said, "I'm going to break norms," and he was voted into office. So the most obvious answer is, you need to vote out, and in the midterms, you need to vote a check. But if indeed our election systems are imperiled, then I'm utterly terrified. The other formulation of constitutional crises that we have talked about is simply the administration ignoring court orders. And I harbored more hope, and maybe I still naively, maybe foolishly still harbor hope that the court is going to act. I think safe to say only in one instance did the court really, after the government had lied to lower courts about the deportation and removal of people to El Salvador, did the court simply really say, you need to facilitate or effectuate the return of this individual, and in the same breath said to lower courts, don't you dare encroach on the deference that is owed to the president in foreign affairs. So I still, I guess, harbor some hope that this court is going to recognize that some restraints are necessary in the name of due process, in the name of avoiding a constitutional crisis, in the name of avoiding imperialism. But I may be a fool.
A hopeful fool is a good fool.
Thank you to everyone. The speakers will now accept questions from the audience. We will try to get the first questions from the students, and then afterwards it will be opened up to everyone else. Please keep your questions concise and respectful. So, yeah. If you want to ask a question, raise your hand. Yes, students first then.
Hi, I'm Robin. I'm a senior. I'm finance and accounting major. I don't think the microphone's on. At the bottom. Hello? No.
Want to just take this one? Oh.
Thank you. Hi, I'm Pravin. I'm a senior, finance and accounting major. My question is, we've seen what happened in January 6th, the horrific event, and how hard it was for a peaceful transfer of power. Do you think our nation is ready for a removal of president if it ever does happen in the future? And do you think that there's if a president breaches the Constitution or should be removed from power, that the nation should be willing to pay the price if an insurrection or suppose that the president's supporters create sort of the chaos at a much larger scale?
Well, first, what's the alternative? I mean, part of the understanding and the need and the recognition for what the Constitution created and authorizes is that the framers knew. There is always violence is the default state, but it is also the primary state we fundamentally want to avoid with the exception of dictatorship and totalitarianism. Right? Trump was right. There are some people who want dictators, and there are some people who want dictators in the United States, as long as the dictator works for them, or they work for the dictator, right, depending on your perspective. And the threats of violence have always been a fundamental means of undermining the legal system and the political system. Right? We will revolt. We will burn this down if you do this. Emancipation, Reconstruction, civil rights, all fundamentally undermined by acts of violence and threats of violence. And I think when we look back on history here, right, we kind of judge that those kind of concerns and bending to those threats has been more problematic, right? And so the Supreme Court, when it looked at whether to keep Trump on the ballot, one of the questions they asked is, look, if you can remove Trump for this basis of insurrection, what's to keep the next political candidate from the other party from facing the exact same challenge? Well, my response is the facts. Right? And so to the extent that we care about due process, there is a means of determining the facts for purposes of legal conclusions. Right? The Supreme Court could have said, you need to be convicted of engaging in treason for that section to apply. They didn't say that. Right? They could have said that Colorado didn't provide the proper process for this. They didn't say that. They could have said that relying on Congress's finding, a bipartisan finding by the Congress, was hearsay and inappropriate. They didn't say that. Right? So they said, the threats that this might be abused was sufficient to allow a bad actor who fundamentally should have been excluded and not elected by the so-called will of a people or the people. That's one reason why we're here.
Professor Koo, Professor Cover, hello. Thank you for this talk. I have a question to try to ground sort of some of the discussion today in terms of things that we're seeing people start to do on the ground, because I think I'm worried that the trend line is going in a really bad direction, right? I think the murder of Charlie Kirk last week is an indicator to me, right, that the populace, right, is in need of a sort of moral leadership that I think is missing, right, from our politics now. Like, people are crossing lines, right, like in interpersonal interaction that are becoming very untenable, and it's becoming very scary just to see every day. It's been happening for a very long time, but I think it's in the public with very large figures. It's in everyone's face now that violence is on the table, right? From your perspective, how does the trend line get reversed, right? What does it take to change the nature of political leadership to kind of recenter, right, that foundation? Because I think that fundamentally, I think you vote who you want to vote in, but the polarity problem doesn't get solved just by voting for someone else, right? There's a leadership problem, a character problem, right? So thoughts on that?
Well, yeah, I mean, I think largely, and I know we have a lot of political science folks here too. I mean, I don't know that a lot of this is so much a question of law, right? And in that regard, to, I guess, connect it to the other argument, we have actually not seen the civil disobedience that I think we should be seeing. And I recognize, right, with the events of last week, how maybe freighted or fraught that may feel. But I'm not going to throw stones in glass houses. I can look inward as well. But civil disobedience has been, I would say, meager at best, given what we're talking about. The other dynamic, I guess I would say, and I point to the party in power, which is maybe only so helpful and responsive, at least my understanding, and again, I know we have political scientists here, what's critical to sometimes stopping authoritarianism, I think some at least have found, is that the party in power of the would-be authoritarian takes action and tries to mitigate some of the worst impulses. And so, it's easy to to throw stones at the Republican Party right now, but I think we know there's a lot of members of that party who do not agree, but are cowed by the president and by certain forces. And I think we need some of that to come together. But I share the fear.
Just a quick response. I mean, what I think we're experiencing is decades worth of efforts to break social ties and broader sense of community that do in fact bind us. And I'm going to quote a science fiction story that I love, where the character says, the thing about civilization is it keeps you civil. Right? Get rid of one, you can't count on the other. And so to the extent that we have tried to remove the idea that we are one community, one nation, it leads to the fragmentation of groups, and it makes it possible for groups to want to, fight for and vindicate their own interests, to fight for the injustices against them. And so you have the murder of Charlie Kirk, you have the arson of Governor Shapiro, you have the murder of 2 Democratic elected officials in Minnesota. And so that when those social bonds fray, these actions become more likely. So can we reconstruct those social bonds? Like since this began, I've been telling my students, that is how we can respond in one very clear way. We are in this room as a community, right? We can act for ourselves in a way that ensures those social bonds, as much as we disagree. But that's very difficult, right?
Just as a reminder, please keep your questions concise.
That was a concise.
Quick question. So you both made the distinction between the president being allowed to act in defense of the country versus them not being allowed to unilaterally declare war. So my question is there any precedent or case law surrounding a scenario where the president authorizes some action that could legitimately be considered a declaration of war by another country, but they kind of evade that label by not explicitly calling it that? Something like the recent strikes in like the Iranian military sites is something that comes to mind for me.
No, absolutely. I mean, Professor Cover gave you the number of undeclared, unauthorized acts of armed aggression. Would probably be one way to describe that, from the United States against others outside. Vietnam was not a declared war. Korea was described as a police action. Our war on terror was through the authorization of use of military force. And as Professor Cover suggests, right, there are multiple statutes on the books that talk about and give president emergency authority. So yeah, we do that. And the question is, how much leeway and do we give to a president to define what an emergency is, what national security interests are, right? So there are some wonderful historical works on what the CIA has done over the course of its existence, and the number of emergencies that have justified various acts, including the overthrow of elected governments, are scary and in many respects very hard to justify and explain later. Yeah, that was actually an emergency in the national interest.
Yeah, and I guess I would only add to that, to complicate it, I think there are instances where we can point to where the president has acted for humanitarian reasons, describing them as in national interest, that you might be quite okay with, right? Engagement in Kosovo, in helping the Yazidis in Iraq. I mean, so it gets complicated in the sense that at times we might actually we're on team president for that. But the danger of buying into that precedent is, at least if you look at it through neutral eyes, is how do you distinguish it from maybe the war that you're not on board with?
Well, it does require a bit of moral neutrality under those circumstances. Yeah.
In the interest of time, this will be our last question.
Thank you both. You both used the Federalist Papers, Professor Kuhn more so than Professor Cover, but I wanted to ask, given the evolution of the United States, both domestically and internationally since those papers were written, how fair of an argument is it to use those papers against previous and current administrations in the 2000s and beyond?
completely fair question. It is one that I do not hang my hat on the Federalist Papers on any given basis or any given argument. I used it very specifically because in most instances, not all, the defenders of the unitary executive tie it back to that original, or what they deem to be the original understanding. Because the primary argument that they use to attack their opponents is, well, you're reading some personal preference, some outside political theory, philosophy, they'll often make fun of Thoreau somehow in this process, into the Constitution. And so, especially if your argument is historically based, what does the history say? Let's engage in an honest debate and discussion. Right? So if it's about policy, evolution of norms, let's talk about that. But if you're arguing that this is based on the framers' understanding and therefore we're independent, we are just calling balls and strikes, I want to see the evidence of that, and I want to be able to challenge that. So yeah, there are different ways to look at it. I only think it's fundamentally important if that's your basis for your argument.
Yeah, I would largely echo that. I'm not an originalist.
Thank you, Professor Koo and Professor Cover. I would now like to invite Mr. Batarse to deliver his closing remarks.
Okay. Just before the closing remarks, just two things. One, for Professor Butler's extra credit. I do have his sheets. They're over there. Apologies for not leaving it out sooner. And again, the first year Explorer credit is on the door over there on the right. So if you want that, go and scan the QR code. So, ladies and gentlemen, the Society of Constitutional Policy members express our sincerest appreciation to Professor Koo and Professor Cover for joining us today. We also give special thanks to the Office of the President, Office of Government Relations, and the Provost for their support. And we would also like to thank the following contributors without whom this event would not be possible: the School of Law, Department of Political Science, Center for Policy Studies, the Federalist Society, the student panelists, moderators, timers, and volunteers, and the advisors, Dr. Dole, Dr. White, Professor Lucker, and Professor Turtikoff. Thank you everyone for coming. You're invited to join us upstairs at Ben's place for our reception. And again, we appreciate your time that we share to further reflect on the questions from the panelists and the general public. So thank you and have a great day.